evening and welcome to The Law and You. My name is Stuart Fahmy and we want to welcome you to the show tonight. But tonight we have with us a very, very special guest, Mr. Francis Cole, better known as Frank Cole. Frank, welcome to the show.
Thank you, Stuart.
Frank is a practicing attorney in Santa Clara County. He specializes in criminal law, has been practicing for over 7 years. He teaches business organization at Lincoln Law School, of which he is a graduate. He was also the head and the editor-in-chief of the Law Review at Lincoln Law School. He serves on the bar committee for lawyer assistants, and he is also one of the best-known criminal attorneys, has handled hundreds of cases, and welcome to the show.
Thank you again, Stuart.
Frank, let's start the discussion this evening by talking about the basics of the criminal justice and the process of it in Santa Clara County. What can you tell us about this?
I'm always fascinated by how the process affects the people that are involved, particularly my clients and their families. And the process is so foreign to most people that oftentimes the most important thing that an attorney can do is to keep the family abreast of what is going on and keep the client abreast of what is going on. It's bad enough that they're going through whatever traumatic event that they're going through, whatever trials and tribulations that the family is going through, but when they don't know what's happening to them, they get very anxious. So I like to spend time, because even the best criminal attorneys who do the case properly from beginning to end but don't inform the clients often have clients that end up feeling as though that their cases weren't handled properly. So I often like to go through and tell the clients what the process is, and I think that it's very important for the general public to know what the process involves when a person is arrested. And I think one of the most important things that everybody should know is that every citizen, even if you're completely law-abiding, a citizen is presumed to be aware of what their rights are as a citizen. So it should be known, which it is not, but the Supreme Court expects you to know, that if the police encounter you on the street and come up to talk to you, that you have the right to decline that encounter. If the officer at that point decides to continue with the encounter, it then becomes what we call a detention, which could be an investigatory detention. But that detention has to be based on reasonable suspicion. So, in other words, the officer has to have reasonable suspicion to believe that something illegal is happening. At that point, the citizen then has certain rights that attach to the significance of that. So, usually, people create a lot of problems for themselves at the very beginning of the process because they don't understand that they have the right to decline the encounter, or that once they're detained, they have rights that attach to that.
For purposes of clarification, when you say encounter, meaning that an officer approaches me in the street and starts talking to me and wants to investigate me or question me, that is what you term as
Yes.
an encounter. Okay,
yes.
Go ahead.
And because if you're driving and you are suspected of violating a vehicle code section and the officer pulls you over, then that's not a consensual encounter. You know that you have to pull over because that's the law. And the officer has probable cause because the officer witnessed you violate the vehicle code section. Okay. But oftentimes citizens may be walking down the street and perhaps a crime has recently occurred in the area, or the police are on the lookout for a certain person, and an officer may go up to a citizen and start to ask them questions, and citizens have the right to decline those encounters. At that point, the officer has to determine for herself or himself that there is reasonable suspicion enough to justify a detention. And once they've done that, then they could ask for identification or do other certain police activity. A significant percentage of criminal defendants get convicted because they make statements when they did not have to make statements. And oftentimes they'll ask me, they'll say, well, they never read me my rights, because we all see the TV shows and the movies, and the police are reading the person that they've detained their rights. And the trick is, if you would call it that, What the clients don't understand is that you don't have to be read your rights until you are under arrest. So in between the time that the police encounter you and detain you and the time that you're actually under arrest, and that term has legal significance, they are not required to read you your rights.
I see.
You do have the right to remain silent during that time, but they don't have to tell you that you have that right. And usually it's during that time that the nervous citizen becomes defendant because they say something that they shouldn't say that incriminates them, and those statements can always be used against them.